Good day, ma'am. We are the Group 3, and our topic for today is the areas of the potential liability, unintentional torts, and fundamentals of nursing. Crimes and torts. A crime is an act committed in violation of public law and punishable by a fine or imprisonment. A crime does not have to be intended in order to be a crime. For example, a nurse may accidentally give a client an additional lethal dose of narcotic to relieve discomfort. Giving narcotic medications to patients can cause changes in your heart, lung, and bone functions that can affect your ability to be active. It can also make changes in your heart rate and heart rhythm. Some people find that their heartbeat are more slowly or irregularly when they take opioid medication. What effect do narcotics have on BP? Narcotics can affect the BP because it can cause significant decreases in systematic vascular resistance and blood pressure. Introduction. Crimes are classified as either felonies or misdemeanor. A felony is a crime of serious nature such as murder, punishable by a term in prison. In some areas, second-degree murder is called manslaughter. A nurse who accidentally gives an additional and lethal dose of narcotic can be accused of manslaughter. Crimes are punished through the criminal's action by the state against an individual. A misdemeanor is an offense of a less serious nature and is usually punishable by a fine or short-term in jail sentence. A nurse who slaps a client's face could be charged with a misdemeanor.
Good morning, ma'am. Good morning, everyone. So my topic that is assigned for me is tort. So what is tort? A tort is a civil wrong committed against a person or a person's property. Torts are usually litigated in court by civil action between individuals. So tort almost always is based on fault, which is something that was done incorrectly. Torts may be classified as unintentional or intentional. So let's go for unintentional torts, which is assigned to me. An intentional tort is a type of unintended accident that leads to injury, property damage, or financial loss. In the event of an intentional tort, the person who caused the accident did so inadvertently and typically because they were not being careful. An intentional tort must satisfy three conditions to be considered as such. The defendant caused the injuries, the defendant failed to provide the standard of care of a reasonable person, and the defendant owed the plaintiff an obligation to avoid careless action. The most common type of unintentional tort is negligence and also malpractice.
Negligence. Negligence is misconduct or practice that is below the standard expected of an ordinary, reasonable, and prudent person. Such conduct places another person at risk for harm. Usually, negligence occurs when the nurse fails to follow established policies, procedures, and also the standards of care in the same manner that another reasonable nurse would do in the same situation. Negligence involves an extreme lack of knowledge, skills, or decision making that the person clearly should have known would put others at risk for harm. It can be done by anyone, either they are professional or not. Malpractice. Malpractice is improper or unethical conduct or unreasonable lack of skill by a holder of a professional or official position, often applied to physicians, dentists, lawyers, public officers, and generally included nurses to denote negligent or unskillful performance of duties when professional skills are obligatory. Also, on malpractice, it occurs when a nurse knowingly and willfully does not follow the proper standard of care and patient experiences harm. So for the negligence example, first is failing to record important information on patient chart. Example number two, not assessing a patient condition such as the blood pressure or blood sugar level on time. Example number three, errors when administering the medication. And example number four is failing to report test result to the doctor or other healthcare providers. For malpractice examples, first is if a nurse did not check a medication before administering it and it resulted a medication error to the patient that caused a harm. Example number two, engaging in sexual activity with the patient.
Good day, Ma'am Cheng. I am Terry Baronio, and I will be the one to discuss the components to prove professional negligence and malpractice. So, before a plaintiff can file a complaint about staff or a facility, there are main components that need to be satisfied. Otherwise, there is no firm basis for the malpractice suit. These components are the follows. First is duty. Second, breach of duty. Third, foreseeability. Fourth, causation. Fifth, harm or injury. And lastly, the damages. So the first one is duty. The nurse must have or should have had a relationship with the client that involves providing care and following an acceptable standard of care. Such duty, for example, is evident when the nurse has been assigned to care for a client in the home or hospital. A nurse also has a general duty of care, even if not specifically assigned to a client if the client needs help. It means that the nurse must be there. He or she must be on duty and performing care to the patient even though she is not in charge of the patient. Knowing that he or she wasn't there, it's her or his responsibility to give nursing care to the patient.
Breach of duty is there must be a standard of care that is expected in the specific situation but that the nurse did not observe. Meaning of this, in performing in nursing care, we have to follow the standard of care. For example, something was done when it should not have been done, or nothing was done when it should have been done. This is the failure to act as a reasonable, prudent nurse under the circumstances. Foreseeability, a link must exist between the nurse's act and the injury suffered. There must be a connection between what the nurses do with the injury that occurred to the patient. When a person suffers an injury, the law expects that such a person needs to receive remedial action. The law determines it to be fair that people who suffer personal injury gets recourse.
So let's move on to the causation. Causation, it must be proved that the harm occurred as a direct result of the nurse's failure to follow the standard of care, and the nurse could have known that failure to follow the standard of care could result in such harm. It requires a complainant to show proof that the nurse's breach of duty was the cause of the patient's injury or loss. To prove causation, the damages must be foreseeable. For example, a nurse failed to document a previous dose of an opioid pain medication and administer the second dose. If the nurse doesn't follow the standard of care, it can harm the patient. The standard of care is developed to prevent the nurses from causing harm to the patient. That is why we cannot practice doing shortcuts in performing the procedures because it is dangerous to the patient.
Harm or injury. The client or plaintiff must some type of harm or injury, either physical, financial, or emotional, as a result of the breach of duty owed the client. The plaintiff will be asked to document physical injury, medical costs, loss of wages, pain and suffering, and any other damages. As we discussed in the previous topic, if there are no damages, there is no case even if there are damages. So it is must not came from known or commonly occurring complications or side effects. The plaintiff may claim from direct and indirect remedies just occurred subsequently after the malpractice action. Damages. If malpractice caused the injury, the nurse is held liable for damages that may be compensated. The goal of awarding damages is to assist the injured party to his or her original position so far as financially possible. As we mentioned before, if we keep practice care that is not following the standard care, it will lead to more practice causing injury to patient at physically and emotionally. Thus, be at the safe side, practice the nursing care by following the standard care.
Legal doctrines, principles in negligence. Res ipsa, loquitur, and respondent superior. First is the res ipsa loquitur, Latin for the thing speaks for itself, or it means it is clear and needs no further explanation. It is a legal theory wherein the facts and circumstances surrounding an injury allow the court to presume that negligence has occurred. In an ordinary negligence case, the plaintiff must prove that the defendant owed the plaintiff a duty and that his conduct failed to measure up that duty. However, under res ipsa loquitur, the defendant's negligence may be presumed and thus not need to be proven. The elements of res ipsa loquitur are: the defendant was in exclusive control of the situation or instrument that caused the injury. Second, the injury would not have ordinarily occurred but for the defendant's negligence, and the plaintiff's injury was not due to his own action or contribution. If these elements are met, the burden shifts to the defendant to show that he was not negligent. Res ipsa loquitur typically arises in cases where the negligent act is so obvious that there is no need for evidence of what happened. What must have happened is apparent from the surrounding circumstances. The finder of fact must be able to infer, through common knowledge and experience, that negligence occurred. Res ipsa loquitur is also sometimes applied in medical malpractice cases where something obviously went wrong in surgery.
Next principle is the respondeat superior. This comes from the Latin meaning let the master answer, and is also known as the master-servant rule. This legal notion comes into play in the case of medical malpractice when it can be proven that the employer or the hospital can be held liable for the actions of doctors or employees. This vicarious liability occurs if the negligence or harm committed by the employee occurred during the scope of their normal or routine work performances. This legal concept is more important to plaintiffs in medical malpractice cases because it ensures that there is an institution that can be held liable or responsible. An example to this is a pregnant woman visiting a hospital for a routine visit who complains a severe abdominal pain but is forced to wait for an hour and a half, resulting in an emergency C-section and a baby born with brain injuries. May have grounds to sue for negligence. In that situation, a responsibly prudent nurse would likely recognize signs of fetal distress and make sure that the patient saw a physician in a timely fashion. The nurse may be held directly liable, while the hospital may be held vicariously liable for the nurse negligence. If it turns out that the nurse is not qualified to provide care, and the hospital should have required further into some aspect of her background before hiring her, the hospital might be held responsible under a theory of negligent hiring.